So welcome to the third lecture in the Dean's 70th Anniversary Lecture Series on the Law of International Studies, which is a wonderful initiative taken by our Dean, Professor Amitabh Makhlood. All of us have really benefited from the first two lectures that were given by Professor Pant and Mr. Buha. But what is even more important, it really touched our hearts. So today, we welcome you, Professor Chimni, Professor Chimni, another one of our school's, towering figure in international law. And I request the Dean to felicitate him with a token of our appreciation.
Thank you.
I will now request Professor Hedrick to briefly introduce and then teach.
Okay, thank you very much, Professor Preeti. And I don't think I need to introduce Professor Chimni to most of our colleagues here, but still I think there are some younger colleagues who have come in recent times. I think they will have to they have to know something about it. Professor Chimni is a former professor and then chairperson at the Center for International Legal Studies, which is on the old SIS first floor. He had almost, I can say, 4 decades of association with JU as a student and later as the faculty. And over a period of time, I'm sure number of generations of students have actually worked under him, including myself. And he has been one of the, I'm sure many of you would be, if you are following international law well, I think one of globally, I think very active, written extensively, particularly in the last few decades. The theoretical perspectives on international law, particularly in the context of the third world approaches to international law, is something which has really caught up. And then there are almost hundreds of scholars who are around the world who are working in this area. But if you look at his work, I mean, I have known him also more than for 3 decades as a student and as a student of international law always, but much later as a colleague. His work actually initially touched upon in the areas of refugee law. He as a reader in refugee law, he was academic advisor to the UNHCR for a very long time, and for almost 4 years. Then his other areas of interest related to international trade law and related areas, because his initial work was on international commodity agreements in the when that was the in the context of new international economic order and things like that. So that was also has been published, and he has almost published all his works have been published. The International Commodity Agreement is one of the earliest, I think, of his works, and followed by in 1993 his fascination, and also it continues on the global order, the world order, and international. The first book came up staged in 1993, and the same book, I think, in 2017 he reworked that book and came out with his perspective on the in 2017. The book is on again this reworking that model. He published it. It's called the International Law and World Order: A Critique of Contemporary Approaches, published by the Cambridge University Press in 2017. And most importantly, within the school also, he with Siddharth Malavaripu, Professor Siddharth Malavaripu, I'm sure many of you know, they also came out with an edited book on international relations, essays for the global South.
Yes.
So I think there are about this is very briefly. Of course, he's a Fulbright scholar. He has been whatever in international law you can say, whether it's American Society, he was on the editorial board of the American Journal of International Law, edited Indian Journal of International Law, Asian Yearbook of International Law, Asian, you can name it, all the journals he has been editing or the editorial board, and one of the founding members of the Asian Society of International Law. So I think very briefly, it's a great honor and pleasure to invite him. Of course, he's here today. I think I should thank the dean for taking this initiative, and it was also a great pleasure for us within the Center for International Legal Studies. He came here and spent some time with us, and uh, and this is very briefly. I think I can say, but his work, particularly for us within the school, came from the earlier, of course, the international law stalwarts like Professor R.P. Anand, Professor Amtullah Khan, Professor Mani, in the same, and of course the Professor Tyagi, all of them actually, including Professor Bharat Desai, looked at the concerns of developing countries, third world countries. Some of the work which has been done is really in that sense, questioning the norms in an ongoing process. With that, I think I'll introduction. I think most of you must have read his, continue to read his work, which actually interfaces between international law, international relations, and related areas. So at the end, personally, of course, he was my supervisor. Obviously, I had a large, long contacts with him, long conversations, obviously, and I'm really happy to be here and and introduce him at this, for this conversation, and I'm looking forward to hearing him, like all of you. Thank you.
Yeah. Thank you, Professor Preeti Singh, Professor V.J. Hegde. This works. Faculty, students, distinguished guests, ladies and gentlemen, and all those who are watching this lecture, uh, which is being live streamed. It is again a great pleasure that I welcome you all to the Dean's Lectures, a special series, as you just heard, commemorating 70 remarkable years of the School of International Studies. Today we have the great honor of having as our third distinguished lecturer, a virtual giant in the field of international law, Professor Bhupinder Singh Chimni. The School of International Studies, as you know, has a rich history, and we've had a glimpse of our contribution to scholarship and the world of public policy through the last two lectures. But few can exemplify our sustained quest for excellence than the Center for Legal Studies, which has long been a beacon of cutting edge research and scholarship. As you heard Professor Hegde, pioneering figures such as Professor R.P. Anand, Rahmatullah Khan, V.S. Mani, Y.S. Tyagi laid a foundation for a uniquely Southern perspective on international law. Their groundbreaking work has not only advanced academic discourse, but has also emphasized the importance of a third world approach to international law, advocating for the voices and rights of developing nations in the global legal landscape. Professor Chimney stands firmly in this great tradition of excellence and innovation. As a former professor at our esteemed institution, he has made unique intellectual contributions, as you just heard, that have profoundly shaped the understanding of international law. As Professor Hegde pointed out, his research focuses on critical areas of international law, including refugee law, international economic law, and the intersection of global governance and human rights. His work on the legal frameworks of governing refugees has been particularly influential in addressing the complexities of forced migration and advocating for the rights of those displaced. Throughout his distinguished career, Professor Chimni has engaged with diverse areas, blending rigorous legal analysis with a deeply compassionate understanding of the human experience, and many from a distinctly Marxist perspective. To list only some of his most recent achievements, in 2023, he was invited to deliver the prestigious Hirsch Lauterbach Memorial Lecture, uh, where he delivered a series of 3 lectures on capitalism and the doctrine of international law at Cambridge University. In 2022, he was honored by the American Society of International Law with its honorary membership, which, in the words of the American Society of International Law, is conferred on an individual who has rendered distinguished contribution or service in the field of international law. In 2021, the University London instituted a scholarship in his name for the ME program in refugee protection and forced migration studies. In the same year, he was also received an honorary doctorate from the University of Gothenburg in Sweden. The Hague Academy of International Law has already announced on its website that its winter course in 2025 will be opened by Bhupinder Singh Chimni with a lecture in international law and global justice. Professor Chimni has been Vice Chancellor of the West Bengal National University of Juridical Sciences, but he's also a member of the uh, Droit International, which is apparently equivalent to the FRS in international law, and the number of people who have been a member or an associate member, you can count on the fingers of your hand. It is a great honor and a pleasure to invite him back to the School of International Study, of which he's been a distinguished faculty member as well as an alumnus, to deliver a lecture on how he sees international law, especially from the vantage point of international relations and for all the years that he spent at the School of International Studies, Professor Bhupinder Singh Chimni.
Good morning, everyone, and thank you for coming for this lecture. Allow me to begin by thanking Professor Mattu, the Dean of the school, for inviting me to deliver this talk. I'm absolutely delighted to be here. This is, in many ways, homecoming, and nothing could have made me happier than coming to give a talk at SIS. Thank you, Professor Singh, Professor Hegde, for that warm introduction. What I propose to do is actually to look at the larger context of the larger debates in the relationship between international relations and international law, and in that backdrop, look at a slice of the history of the School of International Studies. When Professor Mattu invited me, he indicated to me that if I could talk about the impact that international law or the discipline of international law had on the school, or the ways in which the discourse of international law shaped the School of International Studies. And that's why I chose this. I chose to speak on this theme of disciplines of international relations law and SIS. What I propose to do is to suggest that we need to, as in other areas of social science, humanities, and international relations, we need to decolonize this relationship between international relations and international law. And after decolonizing that relationship, we need to actively promote the interface or dialogue between the two disciplines of international relations and international law, because I think that dialogue would enrich both the disciplines, as if it were the discipline of international relations and international law. I proceed in these in five steps, so that you have some roadmap of what I'm going to speak about. So first, what I'll do is I'll touch on the relationship between the two disciplines in the interwar period of the 20th century, of the last century, to explain the reasons for the severance or divorce between the two. That there's a historical moment in the 20th century when the divorce between, or the severance or the separation between the disciplines of international relations and international law take place. And we need to revisit that moment to understand where we stand today in the larger context of the two disciplines, as well as the work being done in the School of International Studies. Followed by, I will again very briefly touch on that relationship in the period of the Cold War. In other words, I think this history is the backdrop, is the necessary backdrop in which we need to consider the theme of today's lecture. Second, I will touch on the relationship between the two disciplines as it has evolved in the School of International Studies. So first, the larger picture, then what the relationship was in the School of International Studies, and the reasons for engagement between the two disciplines in the initial periods of the post-colonial era. And there I will look in particular at one slice of that history, the decades between 1960 and 1990. And of course, this is an impressionistic impressionistic articulation of that of the work being done in those decades. Third, I will look at some attempts to renew the relationship between international relations and ILO in the West. There have been renewed efforts to bring these two disciplines together, and how we should view that attempt at renewal of those two relationships, and how we need to formulate that relationship as in the Global South and in the School of International Studies. Fourth, I will just mention some recent collaboration. I think already indicated among those who belong to the discipline of international relation and international law. And finally, of course, there's a lot of ground to cover. Finally, I will look at the future of the relationship, underscoring the advantage of an integrated outlook. That is an integrated approach which incorporates the insights of both the disciplines of international relations and international law. So that's the roadmap of my talk. Of course, I will have to speak in telegraphic language because that's, as I said, a lot of ground to cover. But I'm speaking to stalwarts of international relations and postgraduate students of the disciplines. So I don't foresee any problem there. So turning to the first issue, which is to try and understand why the disciplines of international relations and international law separated. Now, underlying this is the assumption that even in the School of International Studies and on the global stage as well, there is very little interaction between the two disciplines today. And what I'm trying to understand and grapple with is the ground on which this separation took place, which took place in the interwar period of the last century. Prior to that, firstly, the professionalized discipline of international relations simply didn't exist, and much of its discourse was part of the body of work that international law was producing. Now, in the interwar period, we saw a complete overestimation of the role of international law. You have to remember that in the post-First World War period, there was a very active, what is called peace through law movement. And this peace through law movement, which was anchored both in the United States and in Europe, believed that disputes between states, even of high politics, could be resolved through the language and vocabulary, institution, practices of international law. You would recall the major landmark texts in this period. 1899, 1907, there are these Hague conferences that happen in Europe, which produced the first text of alternative or the Pacific modes of dispute settlement. In the period of after the First World War, there's the creation of the League of Nations, the establishment of the Permanent Court of International Justice. In 1928, you actually have a treaty adopted, which continues to be in existence, known as the Kellogg-Briand Pact, in 1928, which renounces war as an instrument of national policies. That is, states who sign on to the Kellogg-Briand Pact renounce war as an instrument of national policy. So there's this great belief, and that's what we call idealism. There was this great belief that any dispute between states could be solved by international law and institutions and its practices. Joseph Kunz, one of the great international lawyers of the period, describes the situation in Geneva at that point of time. Remember, it was Geneva where the League of Nations was centered, which was the heart of global diplomacy, and not New York as it is today. He describes the situation there where delegates from different nations, and this was essentially, of course, European nations, this was a Eurocentric world, European nations who had disputes with each other, came to Geneva armed with libraries of international law works, believing that they could persuade each other to give ground or to amicably resolve a dispute if the law happened to be on their side, if persuasive legal reasons could be articulated, persuasive reasons could be articulated at advance. It was against this idea, and we know that the peace through law movement failed and the Second World War happened. And it was against this form of idealism, this kind of faith in the international legal process, this kind of faith in international legal institutions, against which perhaps the most dominant theory of international relations or approach emerged. That is the classical realist approach, first articulated in the early, just before the Second World War by E.H. Carr, but subsequently more emphatically, more incisively by Hans Morgenthau, the founding figure who published his most celebrated work, translated into all languages in the world, Politics Among Nations. And this, the classical realist approach was a reaction against this idealism. And they said that there was something deeply wrong with not only the thinkers and philosophers of the times, but the elites and the leaders of these nations who believed that international disputes could be resolved through the vocabulary or institutions of international law. And we know, I think all students know, how Morgenthau saw international relations, where both the power and both the means and end of all international politics is power. And he felt, and he gave this famous sentence comes out of Politics Among Nations, that there's this iron law of politics, that international law always gives way to national interests. That's this. And so the critique was so effective. The classical realist critique was so effective that those who were in the discipline of international relations almost shunned as if it were the discipline of international law, because they believed that while international law worked, in general, in areas where power politics was not involved, when it came to core national interests, when it came to power politics, international law always gave way to power politics. And as I've written somewhere, that since the time of Politics Among Nations, one of the great efforts of the entire international legal community is to recover from this critique, the validity and relevance of international law. Now, a couple of points we need to just pause and know about Hans Morgenthau's critique in particular, which again is carried forward later by structural realism as well. First, of course, you have to know a little bit about his biography. I don't know how many of you know about Morgenthau, but he was essentially a student of international law. His PhD thesis The title of his PhD thesis was The International Administration of Justice, Its Sense and Its Limits, which he did in 1929. He published it as a book called The Judicial Function in the International Realm, Its Nature and Limits. So his postdoctoral work, or habilitation, as it is called, was also in the world in international law. And his mentor then was one of the greatest jurists of the 20th century, Hans Kelsen. And both of them were in Geneva, and both were associated with the Graduate School of International Studies here. And making this point is that one of the things you have to understand is that when Morgenthau came to critique international law, he had been studying it for almost a decade. So it was not an uninformed critique. It was a critique which was based on very deep a deep study under the tutorship of one of the great minds of the legal minds of the 20th century. And he continued to publish in international law journals. His well-known article in 1942 on positivism, functionalism, and international law in the American Journal of International Law. So it was an informed commit, but it had two failings that I want to draw your attention to. One of the things that often students in particular do not fully grasp about classical realism is its insistence on the autonomy of the political sphere. That is, classical realism or the realist method is only interested in looking at the political project, believing that the political sphere has its own laws. So from the very beginning, Morgenthau was not interested in the political economy of the global order. He was not interested in what I call the logic of capital. My own argument in my work is that the global order is driven by two logics. One is the logic of territory, that is the sovereign state system, and the other is the logic of capital, that's global capitalism. Morgenthau, by design, did not talk about the logic of capital, about political economy or capitalism, because he believed that the political sphere has to be analyzed on its own terms. Why this is important is, as I'll come to this theme later, that post-decolonization, and that's where we need to decolonize this relationship, the global south or individual nations like India cannot understand international politics on these terms. We cannot neglect the global economic order because that's so critical to our development and also critical to how we should understand global politics. That's the first thing you need to. Second is that his engagement was always with positivism. That is, Morgenthau's engagement was with the mainstream scholarship, which was black letter scholarship, which was positivist scholarship, entirely oriented on state practice. And therefore, he did not have the luxury of debating the more critical approaches to international law, which emerged later, which bring to the table a whole range of other questions that we today need to address, and which exposes the limits of the classical realist approach. So to repeat, they divorced, the severance took place because they said international law was overestimated. It could resolve all disputes. And I think classical realism had it right, that power politics prevailed in certain areas of international political relations. It is its imperialist ambitions, its attempt to subsume everything under the laws of international politics, which was problematic. Now, I'll just touch upon, and then I'll come to SIS as well. Then you need to understand what happens after the Second World War. This critique emerges. 1948, as I said, first edition of Morgenthau comes out, but then the Cold War had already set in. And what is interesting then is that when the Cold War sets in, there emerge two different paradigms of global order, or the global political order, if one may call it that. And these are that on one hand, or to put it differently, what we see in this period is the coexistence of realism in one form of another, which is talking about the world of high politics, the politics of great powers, etc. But it coexists with the creation of a liberal international order, a liberal international economic order. These are two different paradigms. And why are they two different paradigms? Whereas in the world of the global international politics, that iron law of politics, that international law always gives way to national interest, prevails. That does not prevail in the global economic order, and global South nations need to understand this. When it came to the global economic order, they did not say that international law will not prevail. In fact, the Western nations insisted on respect for international rule of law. So whether it is GATT and subsequently WTO, whether it's the IMF, it's the World Bank, and a whole range of global investment agreements, there was no space for, especially for global South nations, that to say that today doesn't suit us, so we are going to neglect the international legal order. Why then? Even today, during the COVID-19, India gave a proposal to the WTO TRIPS Council, saying kindly waive off the TRIPS intellectual property rights obligations, because we want to ratchet up the production of COVID vaccines and supply it to nations which do not have access to it, like the sub-Saharan Africa. And we were not permitted to do that. India could not stand up and say with Morgenthau, international law always gives way to national interests. We had to observe those obligations. We were bound. Likewise, with our food sovereignty issue, the subsidy issue, which is unresolved in the WTO, and I could go on. So the point that I'm making is that the classical realist approach may work for Western nations, global nations, North nations, where the economic dimensions work on the basis of mutual reciprocity and mutual benefits. It doesn't work for the global South nations. A final point here before I go to the SIS is that in this period, Cold War period, there were several political scientists who were trying to bridge the gap between international relations law. They're well-known names. Quincy Wright. He was never an international law. He was a political scientist, of course, one of the giants of international law. Hedley Bull. These are familiar names. Harold Laswell. These were from the world of politics, who were heavily engaged with international law. And then from the world of international law, there was Myers McDougall, Richard Falk, and more recent time, John Ruggie and others who were engaged in bridging these disciplines. But their work doesn't seem to have invited the kind of engagement that is needed. But even this engagement, as I will keep repeating, needs to be subjected to the decolonial movement, where we look at the evolution of knowledge production of disciplines from the perspective of the peoples of the global South. So now I come to, so that's the backdrop in which I wanted to look at SI. So we are aware of the larger debates that were taking place. Now, what's very interesting is to begin with the decades that I'm speaking to, between 1960 and 1990, that there was a very thick engagement between these two disciplines, an engagement that you don't see now. And I will talk about its failings as well. But remember, just to recall, something that continues to do there, the vision of international studies included a simple thing like 2 mandatory core courses on international law for the MA program. This was not an accident. This was very well conceived, well thought out. On the other hand, at least in my time, when I joined the MPhil course, the mandatory course we students in the international law department did in theories of international relations in CPOD, what's called CPOD today. And I went and did a course with Professor K.P. Mishra, who was the leading figure of the center at that point of time. So there was an integrated vision, and the scholars at that time had an intuitive view that we need to rethink the relationship between higher and lower in the light of our own interests and our own position. Now, here is something very interesting that many of you may not know, and these are just some publications. which which are an outstanding manifestation of the cooperation between these two disciplines. In fact, IR scholars published in journals which, after decades of international law scholarship, only a handful of people have published from international law in these journals. Let me give you these examples, although it's up there for those who cannot. And these are, these examples could be greatly increased. K.P. Mishra publishes in 1961 on India's policy of recognition of states and governments in the American Journal of International Law, in which I think only there are 3 or 4 people who are published in its entire history of 100 odd years. Professor Mishra publishes where he's not a lawyer, he's the leading IR person. If he follows this up by publishing in the Canadian Yearbook of International Law in 1965, then he publishes a book on the subject as well. To give you another example, Professor T.T. Paulos, he publishes an article called India as an Anomalous International Person in the British Yearbook of International Law in 1970, one of the most exclusive international law, the most elitist international law journals that you can imagine. He follows it up by a book on state succession, studying India, Pakistan, Sri Lanka, Ceylon then, and Burma. He writes several articles in the Indian Journal of International Law, Professor Paulos. Professor M.S. Rajan, again a doyen and one of the towering figures of the school devoted to the study of international organizations, pioneered the work there, international relations. What is he writing about? His first major path-breaking work was called United Nations and Domestic Jurisdiction. If you look at that work today, it still is an amalgam of of insights from international relations, international law, and the materials that he uses also flow from both from both that. Later, this is in 58, 78, he publishes on sovereignty over natural resources. He publishes a book, Professor M.S. Rajan. Now, you would imagine, why would he want to write a book on permanent sovereignty over natural resources? He intuitively understood. And then he also wrote the book Expanding Jurisdiction of United Nations, which I reviewed in those times in the Economic and Political Weekly. And if you look at this literature, they intuitively grasped that we cannot separate these two disciplines and their insights when it comes to the global South nations. Because I can't see a professor of international relations today, even in the School of International Studies, writing a book on sovereignty over natural, legally oriented. And there was, of course, a variety. Variety means we know that a plethora of publications on the non-aligned movement, every leading scholar, and I'll come to that. All these were speaking to the question of international law, manifested in the variety of resolutions that the non-aligned movement adopted from time to time. Now, this is serious engagement, publishing in the American Journal, publishing in the British Yearbook, where we still don't get to publish much. And these are international relations scholars without any legal background, because, as I said, they grasp. Now, how do we explain this engagement? So let me try and just mention a few. And I'll have to do it quickly if I have to run through the rest of this. So first thing, what did they individually grasp? They grasped that the foundational principles of international law were of supreme significance to decolonized nations or post-colonial nations. The principle of sovereign equality of state, the principle of non-intervention, the principle of non-use of force. They understood they understood the significance of these principles in the evolving life of post-colonial nations. And I don't know how many of you know that the post-colonial nations, because Africa and Asia were colonized at the time the UN Charter was adopted, we often forget that although we participated as original members in the UN, but as a British colony, we spoke for the British in the. So in 1970, after a decade of negotiations, the nation non-aligned movement adopted what is known as the Friendly Relations Declaration in 1970, which articulates the 7 basic principles of international law, but interpreted in ways that are appropriate for the global south. And this is frequently quoted by the International Court of Justice. So they understood that, and they felt that this engagement with international law was necessary. Meanwhile, again, this is a large subject, but I must say something about the contribution of the Center for International Legal Studies itself. One of the things that you see is the distinct work Global South produces. So if you look at the work of Professor Anand or Professor Khan or Professor Mani, the stalwarts of the center in this period, they turn away from positivism. Much of Professor Anand's work is historical in nature. Neither Professor Rahmatullah Khan or Professor Mani wrote about issues quibbling about interpretations and texts. They were larger engagements with basic themes and questions, whether Professor Khan's implied powers of the United Nations, and of course, the whole range of historical work Professor Anand produced, even contesting whether these great founding figures were really founding figures like Yoga Grotius, but that takes us somewhere, takes us elsewhere. What were some of the other reasons? The other reason, as I've been emphasizing, that they understood intuitively was that that they believed that political sovereignty of the post-colonial nations itself would get undermined in ways if these were not coupled with economic development, with economics sovereignty. And they felt, therefore, that engaging with the economic development concerns, economic institutions were very, very necessary in terms of doing our international politics. And that, of course, was precisely the worldview of the non-aligned movement. I can't get into the details, but the next point is again reason is similar in nature. Where were all the big battles taking place in the post-colonial era? The big battles were taking place in the field of international law, in the domain area of international law. The demand for a new international economic order, 1974, those 2 famous resolutions, the attempt to reorder the regulation of oceans, the famous Law of the Sea Convention adopted in 82, but between 72 and 82, Global South uses that as a testing ground for the transformation of the global order. It's the microcosm, as if it were, of the developments of the efforts of the Global South nations to bring about change. And this was followed by the government as well. Now, you have to remember, for example, that the Indian Society of International Law was not founded by a civil society group, founded by the state. It is the state, that is the government of India in 1962, which actually creates the Indian Society of International Law, and the MEA still is the major funding body. And Jawaharlal Nehru goes to the Indian Society of International Law to inaugurate it. And underscores and underlines the importance of international law for post-colonial nations doing their own global politics. So this vision, all these visions were part of a larger effort in the earlier decades to align knowledge production with national development. That was the broad story. And then, of course, the richness of the work that has been produced. I don't have the time to go into this. I would ask you all to read this literature that I've been indicating. Now, what was the limits of this engagement? Just one sentence on the limits of this engagement. The limits were that these were intuitive, pragmatic responses to bring together these 2 disciplines, the IR and ILR. It was never theorized. So it's not as if the critique of classical realist approach was written and combated or responded to in order to bring these disciplines back. It was not an effort to decolonize this relationship, saying that the classical realist approach in some respects might work universally and in other respects work in the global north but may not work in the global south. These were not explored at a theoretical on a theoretical plane. And so what happened was that as soon as some of these actors, that is, these professors left the School of International Studies, the relationship itself got diminished and over time severed. Because if this had been theorized, then this relationship would have been passed on in the classroom through subsequent teachers. No, to my last slide, just stop me whenever,
No,
Amitabh, that
absolutely
you,
not. It's fascinating.
like good professors, we can keep speaking endlessly. So this is what's happening now between 90. Now my feeling is, and this is again impressionistic, as I said, this is an exploratory. I think by the mid-90s, the relationship gets severed. As these actors leave, Iyer and Ilog go their separate ways. It's very interesting and the subject of another lecture because some of the central characters in that in that story are present here. That what happens in this period is that you then have the beginnings of the teaching of theoretical approaches to international relations. The mid-90s, Professor Bajpai, Professor Mattu, Professor Varun Sari, they bring in a whole, and they train a whole generation of international relations scholars. And it's my understanding, and forgive me, that I think it is a particular accent on the teaching of these international relations theory, which, in a sense, imported this severance or divorce into pedagogy of IR. That at least was one reason that this intuitive, pragmatic relationship was not taken forward. Now, meanwhile, what we have to understand now is where we stand today. Again, we need to go back to the global picture here. Now, at the global level, since the mid-90s again, there have been very, very great efforts by some of leading figures in the West to try and bridge this divide. So firstly, the names, big names are Kenneth Abbott, Anne-Marie Slaughter, Jeffrey Dunoff, Mark Pollock, John Ruggie, and many others. But Slaughter was also the Assistant Secretary of State in the Clinton in the Clinton administration, a very powerful figure. She was the Dean of the Harvard Law School, Dean of the Princeton Woodrow Wilson Center, and she's written books and several articles just with the title International Relations and International Law, saying how they need to use the insights from both these disciplines to take both forward. On the other hand, there was a response from one of the leading figures of international law, Marty Koskanemi, who felt that while this was welcome, but the suggestion seemed to be, or that the debate goes on, the suggestion seemed to be that international law was going to play the role of a younger brother. So this was a hegemonic IR project in which the normative world would find a secondary place because it would be subjected to the nature of international politics in the post-Cold War era. Remember, this is happening in the post-Cold War era, and one of their projects is how to disseminate. There are a lot of issues there. One issue was that state and society relations is not sufficiently studied by international law. We need to bring it in. We need to disaggregate the state and see how Western thinking can be disseminated. So the judiciary in India, for example, uses precisely the same principle, norms, etc., to decide a case as the US Supreme Court does, and what this means. So they were interested in these large questions, but the backlash from the international law was, which, remember, the hermeneutic sciences are as old as the written word. Theology and law are among the first disciplines which evolve in the world. And for them to accept the subordinate position under a discipline which they feel, oh my God, middle of it seemed unacceptable. That's the backdrop. But what it did was it brought into currency the idea that these two disciplines need to be bridged, that they both offer insights that we need to bring together to enrich both and to say much more meaningful things than each one was saying on its own. In this backdrop, we started some work. I'm just giving one example here about my own and sort of work with Professor Siddharth Malwarappu. He, of course, and this is to the credit of Professor Bajpai, who was a supervisor, was writing his work, which eventually was produced as a book on banning the bomb. And if you look at his book, Banning the Bomb, so much of it is about international law. There are chapters on the ICJ's advisory opinion on the legality of the threat or use of nuclear weapons. I remember him, and which was a great initiative, him flying off to Sri Lanka to interview Christopher Viramantri, who had given one of the separate and dissenting opinions in this advisory opinions. And I still have a photograph with him and Viramantri when he came to Delhi. And then in my own work, if I may indulge myself for a moment, so in my own work on international law, world order, critique of contemporary approaches, I try of course, within my own limitations and knowledge and understanding, engage with international relations. So one of my chapters is devoted actually to Morgenthau and the classical realist approach and its critique from an international law perspective. So these are what I call green shoots. And this, I'm sure there is so much else that is happening that I'm not aware of. So I apologize for that. That brings me to the final point. Why do we need to have this dialogue? And why do we need to decolonize this relationship? We already have tried to allude to this, some of these reasons. But let me mention a few in closing. Of course, serves India's national interests. You take all our key national interests, you will find that international law implicated in some form or another, whether it's use of force, whether it is water disputes with China, with our other neighbors. My own sense is, and having worked in that area, that what is called international water law and its basic principles are very key to resolving some of these disputes. They're key as background material, because a sense of the basis on which these disputes can be settled have been codified by the International Law Commission, for example, in the 1996 ILC Convention on Non-Navigational Uses of Water Courses. On use of force, of course, we know sometimes we have undertaken action for which we have offered, I don't want to mention them, they offered all kinds of justifications. I think you have to learn from the United States. United States violates international law all the time, but it will justify every single action of it in the language of international law. It never says, I'm a superpower, I'll do whatever. Donald Trump does say that, to be honest, from time to time. But at least the Democrats and earlier even the Republican leaders, they would justify it because they understand to have law on your side is to have legitimacy on your side. The international law politics is not simply about power. It is to a larger degree also about legitimacy. And legitimacy is comes in through. So from a national interest point of view, we have to use both these discourses. And the fact that the Foreign Office, the MEA leaders, as if it were, are not trained in international law, I think causes a certain deficit. They are, they are not short of intellectual acumen to defend India's national interest. They are some of the best in the business. But at the same time, if they could use the resource of international law we would be much better. I feel we would be much better off. A second, of course, is writing intersectional histories. Remember, internationalization all said and done, there's still questions about whether it's a discipline, but it is still a century old, And so a lot of the pre-20th century history, which is the colonial history, which is the history of the colonial project or even the pre-colonial project, has been written by other disciplines, in particular by international law. There's been a historic turn in international law. Much of this colonial history or the history of colonized nations is being written in the domain of international law, which is not about quibbling about that clause or that provision. That's how you imagine international law. It's all about rewriting challenging the Eurocentric history of international law. A third reason I already mentioned, that when it comes to the global or economic order, which is very critical to global politics as well, we can't say what the classical realists said. I'm just re-emphasizing that. We are bound by these. Today they say WTO is dead, multilateralism is a retreat. I keep telling my students that's for them. Where is it in the retreat for us? Can you violate WTO law? Can you go back on commitments to the IMF and the World Bank? Ask your neighbors. Two of them are in the crutches of the IMF. Ask them whether they can simply walk away from their obligations. If they don't, get their act together, they will be denied. They will be denied future installments. So that's one. Two last things. One is that for the first time in history, and this is very important, something again requires a lot of attention. We are addressing issues, societal issues, global issues, which are very different from issues that we have ever addressed in the past. And these two are climate change and artificial intelligence. Between these two, they are going to reorder, and I mean it literally, many of us will not recognize the world in the next 10 years. There is now consensus, and I don't know if you know, in the case of AI, the head of AI in Google resigned, who's one of the founding figures of AI, saying he was scared at what was forthcoming. Likewise with climate change, for the first time you have a global issue which transcends boundaries, which threatens planet Earth, and if these two non-boundary issues, as if it were, cannot dissolve the boundaries between disciplines, then nothing can, because these have dissolved it at the level of the real world. The real climate doesn't recognize boundaries, sovereign boundaries, or whatever. Nature does not understand these. And we have to remember that the professionalization of disciplines only happened since the latter quarter of the 19th century. Earlier, there was no professionalization of disciplines. Immanuel Kant, what? Philosopher, what? Political scientist, what was he? What was Adam Smith? What was Karl Marx, or what was Hegel? So you cannot categorize this. And I think we are coming back to the renaissance of that kind of scholarship, that kind of knowledge production, because the real world impinges it on us, compels us to do it. And I feel AI, and I hope there is sufficient engagement in school with AI, because if you follow the developments that are going on there, they are very, very worrisome. It won't be long before there would be they're already semi-conscious AI. That is, AI by definition today is something that can take its own decision. And they're already doing it in automated weapons use, etc. But what we are going to see in the next decade is something which is very a Frankenstein monster in the offing. Final point I will make, and I'll stop there. Also, that we need to integrate epistemic approaches. So this is something that we worry of from my own sort of third world approaches to international law perspective. That unless we integrate different approaches, so just give you an example, again, for lack of time, and I'll stop there. So in 1 year in the last century, in 1991, for the first time you see the feminist approach emerged. The feminist theory has a long history. Feminist theory of law has a long history. But feminist theory of international law relations emerge in 6 months of each other. So Anne Tickner writes a book on gender and international relations, and 6 months prior or after that, I can't remember. Hilary Charlesworth, Christine Chinkin, and Shelley write their pioneering piece in the American Journal of International Law on the feminist approach to international law. And yet that divide continues. So you study feminist approach to international relations when you do your course on IR theory, and then you'll do feminist approach to international, at least hopefully so, when you come to the courses in international law. We can't afford this. Patriarchy is still the founding institution in the world today. Patriarchy is very aggressive today. Patriarchy is pushing back. There's a backlash you can see everywhere. And unless you are able to integrate the anti-patriarchy ideas, practices, institutions, etc., you will find that patriarchy makes a comeback in ways which are right now very difficult for us to imagine. The emergence of the right wing, you look at how the US Supreme Court is responding to abortion, you look at the vocabulary that is being used in world over, you will find. And it's very important for us in the School of International Relations to be able to integrate from all discipline standpoint, but most certainly from between IR and ILAW. So I'll conclude by simply saying that, as I said, this is an exploratory lecture. I didn't have access to so much of the material. That remains a problem in the global south. I don't know how to go through the international studies without being a subscriber, etc. So I thought, but I'll at least offer to you some thoughts, some ideas, some clues about how we need to restore this relationship and why. And that why, in particular, is to decolonize that relationship. But the last sentence is to decolonize, not to turn nativist. That I want to underscore. To decolonize, not to turn nativist and say that we always knew it. Because so much of a critique is parallel. But we need to be cautious that we don't turn nativist because that would also become problematic. Thank you all for your patience and your indulgence, and apologize, Professor Mattu, if I've gone over time.
Oh.
Thank you.
So, Ms. Chimni, we could have well continued to hear you for another hour. This was a breathtaking, absolutely brilliant, much more than an exploration. And I think the most persuasive case for why we need to break our silos and why a dialogue, much more than a dialogue, much more than an intellectual dialogue, continuous engagement between international law and international relations is so important. Strangely enough, someone who's, of course, more nativist, a Russian philosopher, Alexander Dugin, was visiting JNU, and he emphasized the importance. He says the most important thing that we can work for, whether it's in Russia or in India, is epistemological sovereignty more than anything else. Of course, that raises a large number of questions, but thank you very much for really, in some ways, also demonstrating why you are the leading light of the discipline.
Good afternoon to everyone. I really feel privileged and honored to propose a vote of thanks at this very special occasion, Dean initiative to 70 years excellence of the SIS, and we are really grateful to Professor Chimni that he picked what you can say, set the tone for subject like highlighting decolonization between IR and law, and then sharing the 70 year of showing the works of the 70 years of the SIS throughout his lecture. And the generation which is now been coming up to see these all works, how it has contributed the relationship between international law and international law. And the sir's work has been no need to mention on that one. His teacher, students are proud of his work, but more than that, even his teachers were proud of the Professor Chimni's work in the sense that Professor Anand and Professor Khan used to cite his works and also ask all of us to read several times to understand the nuances developing on the issues. So his work has been tremendously been what can accepted throughout the world, and that's he is a towering figure in terms of that taking forward the Asian African approaches. What Professor Anand had said a long time back through his writings, he take forwards and that's still we could see from this part of the world. We proud that someone from this part of the world who take forward the interest of the Asian African, particularly India, and even sometimes if scholars are being found difficult to position itself on several certain issues, Professor Chimney's work would be the best way to see what position could be drawn on the issue. So this word, I thanks to Dean for having this initiative, celebrating 70 years of the excellence of SIS, inviting Professor Chimney to deliver these lectures, and I'm quite sure everyone mesmerized by his thanks to all faculty, students who had joined and become part of this very special occasion, having Professor Chimney at the schools. Even what we should look forward that in should have more and more visit from Professor Chimney to shape the coming generation to also provide a similar thought what he is continuing. So thanks to sir for being to the coming to the society and coming to the ISIL and delivering this excellent lectures at this occasion.
Yes, sir.